Most people go to work every day without thinking too much about their legal rights. Until something goes wrong. A sudden dismissal, a pay dispute, a toxic manager, or being treated differently and not knowing why. And at that point, one question suddenly matters more than anything else. What are my actual rights at work? So, let's break it down in 4 minutes. Simple, clear, and real-world focused. First, your right to a contract. Every employee in the UK should receive a written statement of employment particulars. In plain terms, that is your contract details. It sets out your pay, hours, notice period, sick pay, and key workplace rules. If something is not written down, it can still sometimes be implied, but the contract is your starting point for almost every dispute. So, we recently advised an employee who was promised a bonus every year, but only verbally, you know? It was never actually included in writing. When the bonus disappeared, it became extremely difficult to prove entitlement. That just goes to show how important contracts really are. Second, let's talk about your right to fair pay. You are entitled to at least the national minimum wage or national living wage, depending on your age. And you're also entitled to be paid for all the hours you actually work. That includes overtime in many cases, depending on your contract. Unpaid overtime is honestly one of the most common issues we see, especially in senior or salaried roles, where people feel pressure to just get the job done. Third, your right not to be unfairly dismissed. If you have worked for your employer for 2 years or more, you usually gain protection against unfair dismissal. That means your employer must have a fair reason to dismiss you, and they must follow a fair process. We often see dismissals where the reason sounds valid on paper, like performance or capability, but the process behind it is rushed or poorly handled. That can actually make the dismissal unfair in law. Fourth, protection from discrimination. You are protected from discrimination based on characteristics such as age, sex, race, disability, religion, sexual orientation, pregnancy, and, more. And this protection applies from day one of employment, not just after 2 years. For example, an employee returning from maternity leave who is passed over for promotion without a clear reason may potentially have a discrimination claim. Fifth, your right to a safe workplace. Employers have a duty of care to protect your health, safety and well-being. That includes physical safety, but also in many cases, mental health. If an employer ignores serious stress, bullying or workload concerns, they may be in breach of that duty. We've seen cases where repeated warnings about excessive workload were ignored until the employee became unwell and signed off long-term. By that point, legal issues had already escalated. Sixth, your right to be treated fairly during sickness absence. If you are off sick, you still have rights. Employers should not simply assume long-term illness means automatic dismissal. They are expected to consider medical evidence, communicate reasonably, and explore adjustments where appropriate. And finally, your right to challenge decisions. If something feels wrong at work, you are not powerless. You can raise grievances, appeal decisions, seek mediation, and in some cases, bring claims to an employment tribunal. But timing matters, because strict deadlines apply, especially for tribunal claims. So what is the key takeaway? Your employment rights are not just legal theory. They are practical protections that affect your pay, your job security, and your well-being every single day. But they only help you if you understand them early enough to act on them. At Blackstone Solicitors, based in England, we help employees understand and enforce their rights in unfair dismissal, discrimination, settlement agreements, and workplace disputes. Because knowing your rights is the first step. Using them is what really protects you.